We are going to start with the Protection of Women from Domestic Violence Act. आपने Yes, so we are going to start with the Domestic Violence Act of 2005. See, understand that there are certain legislations that we have been dealing with, like the Juvenile Justice Act. Now we are dealing with DV Act. These are all welfare legislations. They are meant for providing special provisions for a particular class of the society, for a particular segment of the society. As the name itself suggests, Protection of Women from Domestic Violence Act. इसकी जरूरत क्या थी? इसकी जरूरत क्या थी? इसको समझने की कोशिश करते हैं. See, understand, since a very long period of time, women were the victims of different forms of cruelty, even discrimination, be it social, be it in terms of economic opportunities, be it in terms of marital bond, marital ties, be it in terms of education, etc. You understand that the position was so sensitive that specific laws were needed even then. For example, you all must be aware of section 498 capital A of IPC, which dealt with cruelty against women by her husband and relatives. So if the husband or relatives of a married woman, they subjected her to cruelty, it was specifically punishable under 498 capital A. Same provision was retained in section 85 of the Bharatiya Nyaya Samhita as well. And in section 85 of BNS, we have a punishment of 3 years and fine for any person who subjects a woman to cruelty, including husband and the relatives. And cruelty, the parameters are defined in section 86 of BNS. See, what I am trying to outline here is what is the need for this law. Why have we enacted a specific legislation, special legislation called the Protection of Women from Domestic Violence Act of 2005? What is the need? You understand, primarily the Domestic Violence Act is a civil remedy. Please understand. Primarily, it is a civil remedy that is being enforced. And be it the Vienna Accord, be it the Beijing Declaration, be it UN CEDAW, I will make you write all this, don't worry. We have been signatories to a lot of international covenants wherein it is mandatory for us to protect women from any unwanted, unwarranted discrimination. And ऐसा नहीं है सिर्फ कि डोमेस्टिक वायलेंस एक्ट ही इकलौता एक्ट है. दिस इज वन ऑफ द पिविटल लेजिस्लेशंस. देयर आर अदर सच वेलफेयर लेजिस्लेशंस एज वेल. फॉर एग्जांपल द डाउरी प्रोहिबिशन एक्ट, that also is somewhere or the other putting an end to a very, very cruel practice of dowry, right? So there are different legislations, the PCP and DT, Preconception and Prenatal Diagnostics Techniques Act, that also somewhere or the other is in the benefit of women. What I am trying to say is these welfare legislations are needed. इनकी हमें जरूरत होती है so that we can put an end to certain discriminatory practices. This law again is very important. सारे स्टेट जुडिशरी एग्जामिनेशंस में पूछा जाता है, प्रीलिम्स में भी, मेंस में भी, और ये और भी एग्जामिनेशंस के लिए काफी इंपॉर्टेंट है. एपीओ एडीए भी एग्जामिनेशंस काफी हैं जिनमें ये लॉ डेफिनेटली डील करा जाता है. जैसे हमने जेजे एक्ट को याद करा था, जैसे उससे पहले भी हमने लॉज को याद करा है एक्सेट्रा. आई थिंक आप लोगों को जेजे एक्ट लगभग याद हो गया है. कोई समस्या तो नहीं आ रही है कुछ उसको मेमोराइज करने में या कुछ समझने में? एनी प्रॉब्लम? श्योर? कोई कंफ्यूजन, कोई डाउट? आई डोंट थिंक सो अभी तक कुछ होना चाहिए. अगर कुछ है so you can very well reach out to me. Nevertheless, we'll do the same with DV Act also, and this is fairly easy also. मतलब this is a shorter legislation and it is easier to remember also because it does not have much complexities involved in it. Fine. Before we start, let us go towards the preamble. Just read the preamble with me and then I'll make you write the basic essence, the purpose behind the Protection of Women from Domestic Violence Act. See, it says, an act to provide for more effective protection of the rights of women guaranteed under the Constitution who are victims of violence of any kind occurring within the family and for matters connected therewith or incidental thereto. अब आप अगर preamble ही देखोगे तो आपको समझ आ जाएगा that this is not exactly an exhaustive legislation. वो कह रहे हैं an act to provide for more effective protection. मतलब there is protection, we want to give more effective protection. So I don't think so there is a situation wherein you might think that Domestic Violence Act or DV Act 2005 is exhaustive in itself. It is not exhaustive because there are other legislations, primarily the IPC or BNS, which are continuously functioning for protecting women from any kind of unwarranted violence, right? Protection of the rights of women guaranteed under the Constitution. Now, where are the rights of women who have been guaranteed under the Constitution? See, a right which is guaranteed for women, it's not specifically that we are saying that it is a right guaranteed for women, because Article 15 Clause 3 is not a right. It is not a right. It is not a right. है ही नहीं वो. What are we saying? We are talking about Article 14. We are talking about Article 14. We are talking about Article 15 per se, not 15.3. 15.3 is a positive provision which enables the state to make laws. It is not a right. You can't go to the court and say it is my fundamental right is being violated, make special laws for me. It's not justiciable like that. Article 15 and primarily Article 21 of the Constitution, wherein this constitutional ethos needs to be protected. What is the constitutional ethos? We are talking about equality. Again, you should always demand equal treatment. We are saying that you have a right to equality. That means you will get equal protection of the laws and you will have equality before law. Meaning that ultimately law will always and always protect you in whichever way possible. Now that is true for women as well, because if there is a particular segment of our society wherein there has been increased number of or increased instances of or the magnitude of discrimination or let us say cruelty is more, we need to be more sensitive towards it. हमें उस तरफ थोड़ा सा और ज्यादा देखने की जरूरत है. इसीलिए it is protection of women from domestic violence act. अच्छा, and let me tell you, this kind of domestic violence, why have we not chosen protection of women from violence act? We have said protection of women from domestic violence act. You know, it very well signaled towards only one fact, and that fact is that maximum amount of or a great magnitude of violence against women takes place within the four walls of a house. Maximum amount of violence which is taking against women, it is taking place against the four walls of a particular house. It is taking inside that four walls. Now the problem that we face because of this is, that ultimately we are unable to address it in a proper manner because it is happening within a particular house. जब वो घर की चार दीवारी के अंदर होगा तो हमारे लिए समस्या आ जाएगी उस पर्टिकुलर प्रॉब्लम को डील करने में. अगर कोई विमेन के साथ या किसी भी व्यक्ति के साथ वायलेंस, लेट अस से इट हैपेंस इन द सोसाइटी, इट विल नॉट बी अ बिगर प्रॉब्लम. व्हाई? Because it can be addressed, because it is identifiable. But the same thing if happens within the four walls of a house, it becomes problematic. Why? Because jaldi se detectable nahi hai. People don't come forward. They think there will be societal stigma attached. They think, what will the society think? They think, what will my parents think? They think I have children. They think it is my husband. They think it is only my mother-in-law. They think it is only my father-in-law. These kind of emotions come to the forefront. And ultimately what happens is that the accused gets away. Why? Because it is happening within the four walls of a house. ज़्यादा से ज़्यादा क्या होगा फिर? There will be certain sort of mediation. Parents of both the families are going to sit, or whosoever is involved is going to sit. Then they are going to ultimately reach at a settlement. There will be certain heated exchange that will be going on, and then after that everything will go back to normal. Or if not normal, it will ultimately go on. But the problem is, what is the immediate remedy available with that woman who is facing domestic violence, who is facing violence inside the four walls of a house? Extremely, extremely important to understand this. That is why we needed this special legislation, because वो जो चार दीवारी के अंदर वायलेंस हो रहा है उसको कैसे एड्रेस करा जाए, उस बारे में किस तरीके से विमेन को एक कॉन्फिडेंस दिया जाए that yes, if something of this sort happens with me, I have an immediate remedy available. That is the basic purpose behind this particular legislation, and that is why this legislation is extremely important to be studied, because whenever you become judges or practicing advocates, you are ultimately going to be dealing with a lot of matters of life and liberty. Abhi thode time pehle I was telling students that, you know, young advocates, if they are being required to practice, I don't think so it is such a big deal, because you ultimately have to deal with matters of life and liberty. So there were people saying that we are young advocates, nobody is going to give us chance to deal with life and liberty. I am asking you a counter question. Have you developed the necessary research, analytical and oral skills that the senior trusts you to give matters of life and liberty confidently to you? I am wanting to ask you this. I am wanting to ask you this. One senior is one person. He will probably not take more cases because he will not be able to reach at every date at the same point of time on the same day. He needs capable juniors. Are you capable enough? That is my question to you. That's the only question that I'm asking. So we need to develop our skills in a better way, and dealing with these small nitty-gritties of laws, that is something which is very, very important. That is something which is very, very important. That is why we have brought these legislations for all of you. आप समझ रहे हैं? Let's write the basic background, the purpose of the Protection of Women from Domestic Violence Act. Please write. The phenomenon of domestic violence, the phenomena of domestic violence in India is widely prevalent. In India is widely prevalent, and has remained invisible in the public domain. And has remained invisible in the public domain. And has remained invisible in the public domain. full stop. The act of domestic violence, please underline the word domestic or put it in single inverted commas. The act of domestic violence, the act of domestic violence is generally restricted within the four walls of a household, and therefore it is not addressed properly. Therefore it is not addressed properly. Full stop. Though we have provisions in the criminal law, such as 498 capital A IPC, or 85 BNS, but the civil law does not address the phenomena. The civil law does not address the phenomena in its entirety. Full stop. The Vienna Accord 1994, the Vienna Accord 1994, the Beijing Declaration and Platform for Action 1995, the Beijing Declaration and Platform for Action 1995, the Beijing Declaration and Platform for Action 1995, and UN CEDAW and UN CEDAW. This is how it is written, UN CEDAW. UN CEDAW is United Nations Committee on the Elimination of All Forms of Discrimination Against Women. So, and UN CEDAW are some commitments made by our country, wherein there is a need to enact laws to protect women, from being victims of domestic violence, in the society. Full stop. So this is basically the purpose or the essence. Acha, I have also told you about something. Let's write about it. Please give a subheading: nature of remedy under DV Act. Nature of remedy under DV Act. Now, what is the nature of remedy under the Domestic Violence Act? See, there is a case for this. Please write. Punapa Reddy alias Nukala Shanka, Punapa Reddy alias Nukala Shanka versus Punapa Reddy Swarna Kumari, 2016 Supreme Court versus Punapa Reddy Swarna Kumari, 2016 Supreme Court. Please write the reliefs that can be granted through a final order, the reliefs that can be granted through a final order under section 18 to 22, under section 18 to 22, or through an interim order under section 23, or through an interim order under section 23, or through an interim order under section 23 are civil in nature, full stop. However, comma, if the said order is violated, comma, by virtue of section 31 of the Act, the violation assumes a character of criminality. The violation assumes a character of criminality. The violation assumes a character of criminality. Full stop. The very purpose of the DV Act, is to provide a remedy, which is an amalgamation of civil rights of the aggrieved woman, Full stop. Therefore, comma, the DV Act is predominantly of civil nature. The DV Act is predominantly of civil nature. ठीक है? So predominantly the Domestic Violence Act is of a civil nature. Only the violation of these civil orders assumes criminality. For example, in CPC also, when you see there is an injunction, if the injunction is violated, if you see Order 39 Rule 3 capital A or Order 39 Rule 2 also, if you see, you will come to know in temporary injunctions, if it is violated, it assumes the nature of criminality. So that is quite obvious. Fine. Another question, please write. Whether the Domestic Violence Act is prospective or retrospective. Whether the Domestic Violence Act is prospective or retrospective. Whether the Domestic Violence Act is prospective or retrospective. Tell me please, can this particular law be retrospective in application? See, certain answers you will get either in the preamble or you will get these answers at the end of the statute. So let us see what is there at the end of the statute. Ek bari dekho. Do you see something of this sort which either provides for or prohibits the retrospective character? If you see, section 36 suggests act not in derogation of any other law, meaning that this act does not override any other law. तो इससे तो हमें पता चलता है और प्रियम्बल से भी पता चलता है एग्जॉस्टिव तो नहीं, एग्जॉस्टिव नहीं है. वैसे भी सिविल है तो हमारे पास क्रिमिनल तो बहुत सारी रेमेडीज वैसे भी अवेलेबल है, तो एग्जॉस्टिव तो नहीं. Otherwise than that, you will not see anything which suggests that whether this particular statute is retrospective or prospective. Fine. Fine. So we are not able to understand from the Bare Act whether it is retrospective or prospective. So let us understand it through another manner. Let's apply our common sense and then see whether this act is retrospective or prospective. So let us say a woman faces domestic violence. Let us say a woman faces domestic violence before the enforcement of this particular act. So woman facing domestic violence before the enforcement of this act can, when this act comes into force, can she avail any remedy? Basically meaning that let us say this is the date of violence, she faces this violence, let us say somewhere close to 1 year after this, the DV Act of 2005. This comes into force on this date, the 17th of October. I am wanting to ask you, can the woman claim the benefit of the Domestic Violence Act? And I am asking the question, can the woman? I am not asking should the woman. I am saying, can the woman claim the benefit legally under the Domestic Violence Act when the cause of action arose a year before this act came into force? I am not saying होना तो चाहिए, मैं should की बात नहीं कर रहा हूं, मैं can की बात कर रहा हूं. Logically, what do you think? Is it possible? It's possible. Okay. What is your argument? How is it possible? तो यहाँ पे आप 498A IPC या 85 BNS में जा सकते थे. अब तो खैर BNS अब आया है, पर तब तो यहाँ जा सकते थे. वो तो अवेलेबल है ही, तो और जो भी मिले वो ले लो. ये सिविल राइट की बात कर रहा है. तो आपको नहीं लगता कि आर्टिकल 20 क्लॉज 1 का उल्लंघन है? आपको नहीं लगता? आई होप यू नो व्हाट इज आर्टिकल 20 क्लॉज 1. Yes, it is ex post facto laws. Ex post facto laws meaning? That is what I'm asking you. What is the meaning of ex post facto laws? So this is saying that criminal laws will have what kind of application? Prospective application to criminal laws will be given. What about tax? What about tax laws? Can tax laws be given retrospective application? Aren't the tax laws every year given retrospective application? The budget presented this year, is it applicable? I mean, मतलब आप लोग के डे ड्रीमिंग में जीते हो, मुझे समझ नहीं आ रहा है. The budget session is going on. You tell me, the annual financial statement, have you read Article 110, 111 of the Indian Constitution? The annual financial statement, which you call the budget, which is presented, is it prospective in application or retrospective also? So tell me, are tax laws also exempted from ex post facto laws? क्या लगता है? I'm just giving you a question. I'm never going to tell you the answer. Otherwise, it will be spoon feeding. Not very good. Are excluded from ex post facto laws. Okay. What about civil laws? What about civil laws? So can civil laws be given a retrospective application? Can civil laws be given a retrospective application? They can be given a retrospective application. So when in 2005, on the 9th of September 2005, when Section 6 of the Hindu Succession Act was enacted and the daughter of a co-parsoner was made a co-parsoner by birth, that means every partition which is taking place before that particular amendment coming into force should have been reopened, and it should be given retrospective application. Why? Because it is for the benefit of the woman. It is to protect the rights of individuals. So it should have been given a retrospective application then. क्या है? मैं आपसे ये नहीं पूछ रहा हूं कि आपने रेट्रोएक्टिव शब्द का रट्टा मार लिया या एक्स पोस्ट फैक्टो शब्द का रट्टा मार लिया. मैं तो ये जानना चाह रहा हूं कि क्या आप समझ रहे हो कि एक्स पोस्ट फैक्टो लॉज का लिटरल मीनिंग भी क्या है. आई एम जस्ट ट्राइंग टू एसरटेन दैट so that I can take the discussion to that level. पता तो चले कि आप कहां तक जा रहे हो. I am asking you whether you know the meaning, literal meaning of ex post facto laws or not. Understood. Let me tell you in very simple terms. Civil laws can have retrospective application. And since we have just now studied that the Domestic Violence Act is predominantly civil in nature, it can have a retrospective application. लिख लीजिए please इसे. The case is Vidi Banote versus Savita Banote. Vidi Banote versus Savita Banote. This is 2012 Supreme. Write down. The Honorable Supreme Court has clarified. The Honorable Supreme Court has clarified that even if a wife who has shared a household, even if a wife who has shared a household in the past, but was no longer doing so when the act came into force, but was no longer doing so when the act came into force, but was no longer doing so when the act came into force, would still be entitled to the protection, of the Domestic Violence Act, Full stop. The goal of the act is to save women. The goal of the act is to save women from domestic violence, and it should be read in favor of women, and it should be read in favor of women, and it should be read in favor of women who are victims of domestic violence, Full stop. Moreover, the act is a civil remedy. And its retrospective application The act is a civil remedy and its retrospective application will not violate Article 20, Clause 1 of the Constitution. Will not violate Article 20, Clause 1 of the Constitution. अब how and why, the questions that I have posed you can answer. जब आप Constitution पढ़ोगे, so try to examine that. Let's proceed with the DV Act for now. The definitions, Section 2. अब Section 2 में यहाँ पर कुछ definitions है which are very important. For example, A for aggrieved person. Again, a very important definition. A for aggrieved person, meaning what? Means any woman who is, they are saying who is, that means in the present who is, or has been, that means in the past has been, in a domestic relationship with the respondent and who alleges to have been subjected to any act of domestic violence by the respondent. Can you tell me what is the meaning of the word aggrieved? Pidhit, meaning that your right has been infringed. Sorry, तो victim क्यों नहीं लिखा है यहाँ पे? Aggrieved person क्यों लिख रहे हैं? Victim लिख देते हैं. समस्या क्या थी? उन्होंने कहा पीड़ित, आपने कहा victim, पीड़ित victim होता है. तो aggrieved कौन है? I'm not asking the Hindi translation. I'm just asking, do you? So basically meaning somebody, a person whose rights have been violated, somebody whose rights have been infringed. Do you think the rights have been infringed? According to the definition of 2 clause A. Do you think that the rights of the woman have been infringed? It says means any woman is the aggrieved person who is or has been in a domestic relationship with the person and who alleges to have been subjected to any act of domestic violence by the respondent. So do you think that the rights have been infringed? The answer is no. The rights have not been infringed. Why? Because it is just a mere allegation. It is just a mere allegation. And on the mere allegation, we are declaring that woman to be aggrieved, that her rights have been infringed. Victim is a person who suffers loss. Aggrieved is a person whose rights have been infringed. Right? Now, the word written is that she is alleging, she is saying, she is contending, she is complaining that her rights have been infringed. And on her mere allegation, we are saying that she is aggrieved. Meaning what? The burden of proof will always be very high in the domestic violence act. The burden of proof will be very high. Upon whom? The aggrieved person or the accused? Accused. जो respondent है, उन पर the burden of proof will be very high under the Domestic Violence Act. Because you see the definition itself suggests that on a mere allegation we are saying that she is already aggrieved. अभियुक्त, accused को भी accused इसलिए बोला जाता है क्योंकि वो उनके ऊपर एक accusation है. उनको हम convict नहीं बोलते, उनको हम offender नहीं बोलते. We are saying that there is an accusation against you, that is why you are an accused. You are accused of doing this. Whether you have done it or not is later to be seen. Person aggrieved. On a mere allegation, we are saying that she is aggrieved. Meaning to say what? That the burden of proof is very high. The burden of proof is very high. Now, I have one issue for you. Please write the question. Basic हम इसको bifurcate करते जाएंगे 2 clause A को and you will be able to understand. Please write a question. Whether a divorced woman can claim relief, whether a divorced woman can claim relief against her ex-husband against her ex-husband under DV Act for domestic violence committed against her prior to her divorce. Question mark. ठीक है? I hope you all understand. The answer is yes, right? Obviously it is yes. Please write down a case. Juveria Abdul Majid Patni versus Atif Iqbal Mansuri versus Atif Iqbal Mansuri, 2014 Supreme Court. Please write. It was clarified that an act of domestic violence once committed will not vanish or be absolved due to a subsequent decree for divorce. Full stop. Fine. So even if you are an ex-wife, your divorce has taken place, still you can claim the benefit of the Domestic Violence Act. Why are we saying that you can still claim the benefit of the Domestic Violence Act? The reason is fairly simple. The reason is that it is, first of all, having a retrospective application. That means there is no bar to apply this provision in a retrospective manner. आप इसको पीछे जाकर retrospectively apply कर सकते हो. It is very clear. Secondly, you tell me, does divorce automatically dissolve the husband of any cruelty that has been committed by him against his ex-wife? No. Divorce is not something that is automatically going to make you a saint, that now you have nothing to do with each other. Okay, now you don't have anything to do with each other. You are ex-husband, ex-wife, and you are both individuals and free in your life. But at one point of time, you had committed cruelty upon your wife, and at that time she was your wife. Anyway, you are subject to liability. So in the DV Act also, it has been clarified by the Supreme Court. Again, they have not held it because it's something which is very clear. They have simply clarified that you, even after divorce, are liable for the acts of violence that have been committed by you against your wife. Clear? Clear? Everybody? Yes, please. Yes or no? Sure? No confusions? No doubts? Okay. एक और केस लिखिए प्लीज. Please write X versus Y. Easiest cases to remember. X versus Y. X कौन सा X? EX वाला X नहीं, X वाला X. X versus Y. 2025 Delhi High Court. 2025 Delhi High Court. Please write. Please write. It was held that a relationship of parties living together through a relationship in the nature of marriage, put in the nature of marriage in double inverted commas, would also be called a domestic relationship. Would also be called a domestic relationship. ठीक है, फाइन. अब क्योंकि यहां पे डोमेस्टिक रिलेशनशिप शब्द लिखा है इसीलिए मैंने आपको ये बताया. अभी विल डू 2 क्लॉज एफ, तब हम डोमेस्टिक रिलेशनशिप की डेफिनेशन भी देखेंगे, उसमें भी ये पॉइंट डेफिनेटली आएगा. बट सिंस दिस वाज अ रीसेंट जजमेंट आई थॉट इट्स फिट टू बी टॉट हियर एज वेल. ठीक है, अब आप देखो इस डोमेस्टिक रिलेशनशिप का एक्चुअली मतलब क्या है. ठीक है, अदर दे आर नॉट वेरी इंपॉर्टेंट. Domestic relationship, 2 clause F. What is the meaning of a domestic relationship? Means a relationship between two persons who live or have at any point of time lived together. या तो रह रहे हैं या रहे हैं कभी. देखो एक्स वाइफ आ ही जाती है इसमें. या तो रह रहे हैं या कभी रहे हैं. In a shared household when they are related by consanguinity. What is consanguinity? What is consanguinity? Yes, students who have done family law, who are so happy that everything of family law is inside them all together. Consanguinity का मतलब क्या होता है? What is the meaning of consanguinity? Blood relationship. ब्लड रिलेशनशिप, मतलब इट्स अ वेरी सिंपल थिंग. आप बोल रहे हो मैरिज का रिलेशनशिप, तो उसके बाद मैरिज लिखने की जरूरत क्या थी फिर, है ना. कभी कभी हमारी आंखों के सामने ही जो चीज होती है हम उसे नहीं देख पाते. आजकल क्योंकि बिकॉज ऑफ द स्पेशल डे कमिंग टुमारो फॉर मोस्ट ऑफ द सोसाइटी, ये इसलिए मैं ये बात बोल रहा हूँ कि कभी कभार सामने जो चीज होती है वो भी आदमी नहीं देगा. ऐसी चीज आजकल बहुत चल रही है ना, लोग ऐसी फलसफी बातें करनी शुरू हो गए, एज इफ दे आर ऑटोमेटिकली बिकमिंग फिलोसोफर्स. हाँ, क्या कह रहे हैं? टाइम खराब चल रहा है. They are related by consanguinity, that means blood relationship, marriage, that means marital relationship, or through a relationship in the nature of marriage, adoption, or our family members living together as a joint family. So tell me, a sister-in-law and your wife, that means your sister and your wife, are they both in a domestic relationship? Only when they are or have lived in a shared household. That is what they are saying. The primary criteria for determining whether you can come under this act is there first has to be a shared household. ऐसा नहीं होना चाहिए कि फॉर एग्जाम्पल आपको किसी के ताने परेशान कर रहे हैं, आपको किसी की हरकतें परेशान कर रही है, लेकिन आप मजबूर हैं उनके साथ रहने के लिए बिकॉज यू आर बोथ इन अ शेयर्ड हाउस होल्ड। आप दोनों लोग शेयर्ड हाउस होल्ड में हैं, यू आर इन अ शेयर्ड हाउस होल्ड। लेकिन अगर सिचुएशन ये है कि मान लो यू आर अ गेस्ट एट समबडीज प्लेस, यू हैव गॉन फॉर द इवनिंग, इफ यू डोंट लाइक दैट पर्सन, कैन यू सिंपली गो बैक टू योर हाउस? यस। सो कैन वी से दैट यू आर इन अ डोमेस्टिक relationship? Read the definition again. It's very deep. It says means a relationship between two persons who live or have at any point of time lived together in a shared household when they are related by consanguinity, that means blood relationship, marriage, or through a relationship in the nature of marriage, adoption, or are family members living together as a joint family. For example, can a daughter prosecute the father for domestic violence under the Domestic Violence Act? Yes, absolutely yes. हम लोग जबरदस्ती में वाइफ और हस्बैंड और वाइफ और मदर इन लॉ और वाइफ और फादर इन लॉ पे टिक जाते हैं आकर. अ डॉटर कैन ऑल्सो प्रोसिक्यूट बिकॉज अग्रीव्ड पर्सन कैन बी whom? Any woman. Aggrieved person can be any woman who is or has been in a domestic relationship with the respondent. So any person who is or has been in a domestic relationship, that means any person who is or has lived in a shared household, any person who is living or has lived in a shared household and is related by consanguinity, blood relationship. Tell me, is the wife, a newlywed wife, related to anybody in a shared household through blood relationship? No. Except her own children. Whenever they are begotten, she is not related to anybody by blood. Generally. Sometimes there are two sisters married in the same house, that is a different situation altogether. But I am saying that she is generally not related to anybody by blood. So why have they written by consanguinity? Mother can, let us say, file domestic violence case against the daughter. Acha, can you tell me, can a, sorry, can a sister, yes, question is, can a sister file a domestic violence case against her own brother? Yes, no problem at all. No problem at all. Although matlab, it should not happen, but it can be a possibility. It can definitely be a possibility. You're getting my point? So first of all, the primary requirement is that you should be living in a shared household. You are living or you have lived in a shared household, and that too in a domestic relationship. अब ये कोई गेस्ट नहीं होने चाहिए, गेस्ट नहीं है ये. They are people who live in that shared household. Living means you are continuously living in that particular place. आगे चलिए देखिए. What have I just now told you in the case? Respondent. अभी तो बताया था मैंने, रिलेशनशिप इन द नेचर ऑफ मैरिज. अच्छा, एक और केस भी लिखो प्लीज. इट्स अ लैंडमार्क केस, सो प्लीज राइट इट. वेलुस्वामी versus D Patchayyamal. Velusamy versus D Patchayyamal. This is 2010 Supreme Court. Chat 2010 Supreme Court. Please write down. This is related to interpretation of relationship in the nature of marriage. Please write down. The court laid down the essentials. The court laid down the essentials for relationship in the nature of marriage. मतलब ऐसा नहीं होना चाहिए that you are living for 7 days together and on the 8th day you file a domestic violence case. What is relationship in the nature of marriage? Number one, the couple relationship in the nature of marriage is live-in relationship. You are asking this question. वो एक ही बात है, कुछ अलग नहीं है उसमें. ठीक है. Number one, the couple must hold themselves out to society must hold themselves out to society as being akin to spouses, 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 full stop. Second point, they must be of legal age to marry. They must be of legal age to marry. They must be of legal age to marry. Third, they must be otherwise qualified. They must be otherwise qualified to enter into a legal marriage. They must be otherwise qualified to enter into a legal marriage, comma, including being unmarried, including being unmarried. I will stop you for a moment here. Section 5, clause 1 of the Hindu Marriage Act 1955 says that it is a condition for a valid marriage that you do not have a spouse living at the time of marriage. So you should not have a spouse living at the time of marriage. And when you read it with section 11 of the Hindu Marriage Act of 1955, then the marriage which is a bigamous marriage, that means when you marry while your spouse is alive, it becomes a void marriage. So they are saying here that you should be unmarried. So that means that if, let us say, H and W are married, and H and, let us say, W1, they are staying together, they are residing together, no presumption of marriage will be raised, because even if you raise a presumption of marriage, it will be a void marriage since the spouse is alive. Therefore, you should be unmarried if you are staying together. Next, they must have voluntarily cohabited. They must have voluntarily cohabited and held themselves out to the world, and held themselves out to the world जब मैं कह रहा हूं ना held themselves out to the world, you should always go towards section 50 of the Indian Evidence Act of 1872. You should always go towards this. I think it is 45 or 46, somewhere around that in BSA, but it is 50 of the Indian Evidence Act, that when you are appearing in the society as husband and wife, you are doing the puja ceremonies together, which are done by husband and wife together. You are holding yourself out to be as husband and wife. You are meeting people as husband and wife. You go back to the same house as husband and wife. You go for work, care for each other in a similar fashion like husband and wife. A presumption is automatically raised. And the opinion, section 50, what it deals with, the opinion of the society that these people are married to each other, it holds some value, not very great evidentiary value. The probative value is very less, but still holds some value that yes, we have been meeting and greeting them as husband and wife. Getting my point? Next point लिखिए. मैंने अभी क्या बताया आपको? As being akin to spouses, same point, as being akin to spouses for significant period of time. Again, it should not be 7 days, 10 days, 20 days, 1 month, 2 months. As significant period of time. ठीक है? एक और sentence if you want to write, please write after the points. This was the last point. Therefore, comma, every relationship in the nature of marriage is not every relationship in the nature of marriage is not covering every live-in relationship. Is not covering every live-in relationship. Is not covering every live-in relationship. So what we are saying here is that let us say these are live-in relationships. Out of these live-in relationships, there is only a certain category of relationships that can be categorized as relationship in the nature of marriage. Relationship in the nature of marriage. That means relationship in the nature of marriage will definitely be a live-in relationship. But every live-in relationship is not a relationship in the nature of marriage. Those live-in relationships which fulfill these criteria, they will be categorized as relationship in the nature of marriage, and hence DV Act will be applicable. Fine. I hope this is clear to all of you. I hope no doubts, no questions. Great. Let's come back. 2Q respondent. 2Q respondent. It says what? Means any adult male person who is or has been in a domestic relationship with the aggrieved person and against whom the aggrieved person has sought any relief under this act. So first of all, the respondent is that adult male person. समस्या यहाँ आती है that can a woman be prosecuted under the Domestic Violence Act? Can a woman be prosecuted under the Domestic Violence Act? That is the question that I have for you. Can a woman be prosecuted under the Domestic Violence Act? Because it specifically stated respondent means any adult male person who is or has been in a domestic relationship. Domestic relationship meaning you are living or have lived in a shared household at any point of time through consanguinity, through marriage, through adoption, through what? Why are you blank? Relationship in the nature of marriage, or you are living together as joint family members. Right? So they are saying who is or has been in a domestic relationship with the aggrieved person. Who is an aggrieved person? Woman. Woman. Against whom the aggrieved person has sought any relief under this act, provided an aggrieved wife or female living in a relationship in the nature of marriage may also file a complaint against a relative of the husband or the male partner. Meaning what? Can a woman be the respondent? I think after reading the proviso, your answer should change. Should it change? Because it says aggrieved wife or female living in a relationship in the nature of marriage. So specifically we are talking about spouse, female spouse, wife can also file a complaint against a relative of the husband. Now are they defining the gender of the relative of the husband? Okay. Or the male partner. Male partner meaning they are when they are referring to male partner, they specifically refer to relationship in the nature of marriage. तो जो relationship in the nature of marriage है उसमें जो मेल पार्टनर है या अगर आप वाइफ हैं तो रिलेटिव ऑफ द हस्बैंड के अगेंस्ट भी आप कंप्लेंट फाइल कर सकते हैं. Now, my question to you, I have two questions in fact. After looking at 2 clause Q, can you first tell me, can you file a domestic violence complaint under the DV Act 2005 against a guest? Okay. Second question, can the respondent be a woman? Okay. Either both the answers will be yes or both the answers will be no. Acha, can I ask you, how are you saying that the respondent can be a woman? Anybody who can explain? How are you saying that the respondent can be a woman? Yes. Okay. Okay. ओके, वेरी गुड. बट यहां पे ये अडल्ट मेल पर्सन लिखते हैं, प्रोवाइजो है. सो यू आर सेइंग, आई एम एब्सोल्युटली इन अग्रीमेंट विद यू. सो यू आर सेइंग द प्रोवाइजो सेज that the respondent can be a woman as well, because I think you are reading this a relative of the husband, right? You are saying a relative of the husband. Now second question, I will repeat it. The question is, can the domestic violence complaint be filed against a relative of the husband? Okay. So you are saying relative of the husband should be living in a shared household. Why? जब वो प्रोवाइजो में रिलेटिव ऑफ द हस्बैंड इज एन एक्सेप्शन टू द मेन प्रोविजन ऑफ अडल्ट मेल पर्सन, देन व्हाई इजंट द रिलेटिव ऑफ द हस्बैंड इन द प्रोवाइजो एन एक्सेप्शन टू द डोमेस्टिक रिलेशनशिप मेंशन्ड हियर? तो मुझे बताइए, क्या शेयर्ड हाउसहोल्ड जरूरी है? बताइए, क्या शेयर्ड हाउसहोल्ड जरूरी है? हम नहीं है. कौन फाइल करेगा कंप्लेंट? अग्रीव्ड पर्सन. और अग्रीव्ड पर्सन की डेफिनेशन पढ़िए, एनी वुमन हु इज और हैज बीन इन अ डोमेस्टिक रिलेशनशिप विद द रिस्पोंडेंट and who alleges to have been subjected to any act of domestic violence by the respondent. No, I will ask you first. They are saying that the aggrieved person is a woman who is or has been in a domestic relationship with the respondent. Domestic relationship की definition देखिए, relationship between two persons who live or have lived at any point of time together in a shared household when they are related by consanguinity, marriage through relationship in the nature of marriage, adoption or family members living together as a joint family. तो क्या मैरिज से आपका रिलेशनशिप किसी रिलेटिव के साथ या किसी गेस्ट के साथ बन सकता है? ऑफ कोर्स जो गेस्ट्स आपके घर पे आ सकते हैं, यू आर रिलेटेड टू देम थ्रू मैरिज. सो कहीं लिखा है कि डोमेस्टिक रिलेशनशिप में आपका उस पर्टिकुलर घर में एक साथ रहना जरूरी है? बट दे आर सेइंग लिव्ड, तो उससे हमें समझ आता है कि एक साथ रहना डेफिनेटली जरूरी होगा, वरना ये शब्द जो ये यहां लिख रहे हैं, हु लिव और हैव एट एनी पॉइंट ऑफ टाइम लिव्ड टुगेदर. व्हाट इफ अ गेस्ट स्टेज फॉर द नाइट? व्हाट इफ द गेस्ट स्टेज फॉर द नाइट? कैन यू से दैट द गेस्ट हैज लिव्ड इन द शेयर्ड हाउसहोल्ड फॉर 10 days? For 15 days, can you say that the guest has lived in the shared household? You can't say that the guest has lived. So what will you say? Stayed. The guest has stayed in a hotel, Have you paid for staying there? So don't you say that I'm living in a hotel, or I'm living on the street, or I'm living in an orphanage, or I'm living in a hostel. Do you say I'm staying in a hostel? I say that I'm living in a hostel. I'm living in a PG. I'm not staying in a PG. So if I say if I'm going to my relative's house and staying there, so do you think so it is not living in the relative's house? That is my question to you. क्या उसको हम नहीं कह सकते that the person is living there? कह सकते हैं? I think it will be more prudent अगर हम shared household की definition भी देख लें एक बार, है ना? 2S पर आइए please. Means household where the person aggrieved की बात हो रही है, lives or at any stage has lived in a domestic relationship either singly or along with the respondent, and includes such a household whether owned or tenanted either jointly by the aggrieved person and the respondent, or owned or tenanted by either of them, in respect of which either the aggrieved person or the respondent or both jointly or singly have any right, title, interest or equity, and includes such a household which may belong to the joint family of which the respondent is a member, irrespective of whether the respondent or the aggrieved person has any right, title or interest in the shared household. तो ये बात कर रहे हैं कि खुद का हो, टेनेंटेड हो, जॉइंट फैमिली की प्रॉपर्टी हो, आपका इंटरेस्ट हो या ना हो, उससे कोई फर्क नहीं पड़ता. अगर the aggrieved person lives or at any stage has lived in a domestic relationship either singly or along with the respondent. So they are saying anywhere. If you are in a domestic relationship, owned house, tenanted house, joint title, joint family property, no right in the property, does not matter. अगर आप एक शेयर्ड हाउसहोल्ड में डोमेस्टिक रिलेशनशिप में रहे हैं, देन यू आर सेड टू बी इन अ डोमेस्टिक रिलेशनशिप एंड यू कैन बी अग्रीव्ड एंड रिस्पोंडेंट. अगेन माय क्वेश्चन, कैन अ गेस्ट, अ रिलेटिव who comes to stay at your house for a day, for 2 days, for 15 days, for just the evening, if that is a relative of your husband, or if you are related to that person through marriage or consanguinity or adoption, can you file a complaint of domestic violence against that guest or relative visiting your house? Tell me, even for an evening. But naturally, yes. Otherwise, you will be frustrating the very purpose of the act. But naturally, yes. है ना? आप समझ रहे हो मेरी बात कि आप डेफिनेटली ऐसा कर पाओगे. ऐसा लग रहा है ना? लिखिए प्लीज. नहीं, होगा. कैसे होगा? दैट इज द ओनली क्वेश्चन. बट क्योंकि लॉजिकल सी बात है ना. मतलब आपकी सिस्टर इन लॉ है, शी इज मैरिड, शी रेयरली कम्स टू योर हाउस, शी कमिट्स domestic violence. Now, domestic violence does not mean marpit only. It can be taking away your money, taking away your jewelry. It can mean abusing you, taunting you, etc., etc. She does that, but she does not stay. She is very well clear from the purview of the Domestic Violence Act that what is the purpose of the act. मतलब जो व्यक्ति तुम्हारे साथ मतलब उस घर में रहेगा परमानेंटली, सिर्फ उसी को प्रोसिक्यूट कर पाओ. ये तो थोड़ा सा लगता नहीं है, absurd है, अजीब है. फिर तो मदर इन लॉ इज, I am not stereotyping. It is just an example that I am taking that is digestible by all of you also. A mother-in-law will every day call, आजा बेटा, आजा, शाम को आजा, आज ऐसा हुआ था, वैसा हुआ था. शाम को the daughter comes, that is your sister-in-law. She says a lot of harsh things to you, simply goes back home. And she is showing her thumb to the Domestic Violence Act. I don't think so. It's a very good picture. है ना? थोड़ा सा मुझे लग रहा है कि गड़बड़ है. लॉजिक लगा के देखो ना. ऐसा फिर तो ऐसा कोई करना शुरू हो जाए. चलो देखते हैं. एक क्वेश्चन लिखिए प्लीज. राइट डाउन अ क्वेश्चन. पहला क्वेश्चन जो मैंने आपसे पूछा, whether female relatives of the husband can be respondent under the DV Act. Whether female relatives of the husband can be respondents under the DV Act. तो हस्बैंड के फीमेल रिलेटिव्स क्या रिस्पोंडेंट हो सकते हैं? Okay, I have two questions, please wait. Sir, if a woman is unaware of the wife of man she is living with in a domestic relationship, see, in that particular situation, you will get maintenance, that is fine. In that particular situation, you can get some relief also, but you will not categorize relationship in the nature of marriage. Then, प्रोवाइजो, अभी मैं रिलीफ पे गया नहीं हूं कि आपको रिलीफ मिलेगा कि नहीं मिलेगा, मैंने सिर्फ आपको रिलेशनशिप इन द नेचर ऑफ मैरिज की डेफिनेशन बताई. आई हैव नॉट डिस्कस्ड येट दैट. अभी तो 18, 19, 20, 21, 22 हमने रिलीज तो डिस्कस करे ही नहीं. तो जब रिलीज डिस्कस करूंगा तो मैं आपको बताऊंगा कि क्या इन रिलीज को उस महिला को भी दिया जा सकता है who's been defrauded by the husband. But naturally I will tell you. Proviso of section 2Q provides that a woman can file complaint against relative of the husband. The provision does not mention gender of the relative. Okay, I understand your point. Please. ठीक है, मैंने क्वेश्चन लिखवा दिया आपको. Please write the answer. The literal interpretation of definition of respondent, the literal interpretation of definition of respondent implies that respondent can only be an inverted commas open adult male, and double inverted comma since you are quoting from the section itself, an adult male, full stop. However, the Supreme Court in Sandhya Manoj Wankhede, Sandhya Manoj Wankhede versus Manoj Wankhede 2011 Supreme Court has observed that respondent includes the term, respondent को double inverted commas में डालिएगा please, respondent includes the term, again double inverted commas open, female relative, inverted commas closed, full stop. The legislature never intended to exclude the female relatives of the husband. The legislature never intended to exclude the female relatives of the husband. Brackets में लिख लीजिए, for example sister, mother, etc. Brackets closed. Or the male partner from the ambit of a complaint, that can be made under the provisions of this act. Male partner from the ambit of a complaint that can be made under the provisions of this act. Full stop. Next paragraph. In the case of Harsora versus Harsora. In the case of Harsora versus Harsora, 2016 Supreme Court, in the case of Harsora versus Harsora, 2016 Supreme Court, it was further clarified. It was further clarified that the words inverted commas open, adult male inverted commas closed, in section 2 clause Q, in section 2 clause Q will stand deleted, will stand deleted as these words are not in line with Article 14 of the Constitution. As these words are not in line with Article 14 of the Constitution. Full stop. Therefore, the words adult male in section 2 clause Q are OTOs. Are OTO, O-T-I-O-S-E, are OTOs. Are OTOs. Sorry? I don't remember. I remember it as Harsora versus Harsora because generally it is asked like Harsora versus Harsora only. That is the popular name of the case. Okay, if you want, I'll check it, but it's Harsora versus Harsora. Fine. Okay. So I hope you understand this. Now, adult male is no longer present in the definition of respondent. It has been deleted by the Supreme Court through legislation, through precedent. Fine. So now, if I ask you a question, can a female relative be the respondent? Tell me yes or no. Yes. And do you think so that there should be a particular time period of living in the shared household for cruelty or abuse to take place? Do you think so? Okay, right now, I'm not answering this question right now. I will definitely, but not right now. So right now you think that even a guest visiting for 3-4 hours or staying for a night or visiting for 15 days or living for a month in your house, that person will still be eligible to be a respondent if domestic violence is committed. Right now you are thinking this, I hope. Okay, ठीक है. We'll answer this question definitely. Let's proceed further in the act, जहाँ पे इसका आंसर थोड़ी देर बाद हमें मिलेगा, either today or in the next class. Definition of domestic violence. Now, what is the definition of domestic violence? Domestic violence की definition क्या है? How do you define domestic violence? Please remember, there are certain cases of 2022, 2025 and even 2026. I think I have an order. These things need to be done because ये आपके examination में definitely पूछे जा सकते हैं. ठीक है? So I will be dealing with all these also. So don't worry and don't go hither thither by trying to find कि मैं judgment ढूंढ लूँ, मैं इसको ढूंढ लूँ, मैं इसको ढूंढ लूँ. I will give you whatever is relevant at least for the legislation. Now, definition of domestic violence. Sorry. मैं केस बताऊंगा ना तो बताऊंगा सर. बड़ा कठिन हो गया है ना. Nevertheless, definition of domestic violence. देखते domestic violence को define कैसे करा जा रहा है. Let's see. For the purposes of this act, any act that means a positive step, an act. Omission, that means what do you mean by omission? omission meaning negative conduct meaning है तो सर्कुलर डेफिनेशन हो गई, घर कहाँ है, खंबे के सामने, खंबा कहाँ है, घर के सामने, कैसे ढूंढोगे? वी आर नॉट, मतलब क्या ओमिशन का मतलब क्या हुआ? सो बेसिकली मतलब इफ यू से नेगेटिव कंडक्ट तो आई थिंक वो ओमिशन से थोड़ा बाहर चला जाए। ओमिशन का मतलब हुआ दैट यू आर लीगली बाउंड टू डू समथिंग बट यू डिड नॉट डू दैट। नेगेटिव कंडक्ट का मतलब क्या है? नेगेटिव कंडक्ट मीन्स व्हाट? नेगेटिव कंडक्ट, सॉरी, जैसे पॉजिटिव कंडक्ट मतलब मैंने आपको ये बैराक दी, नेगेटिव कंडक्ट मतलब मैंने आपसे बैराक ले ली, तो ये ओमिशन तो नहीं हुआ ना। ओमिशन का मतलब है दैट यू आर, फॉर एग्जांपल, यू आर बाउंड टू ब्रिंग द vegetables and necessary food grains etc, the ration in the house, but you did not. You had to give some maintenance to your wife to visit the doctor and for her own needs, but you did not. So that is omission. That is not negative conduct, that is omission, that you are legally bound to do something but you did not do. और कमीशन, अब जब एक्ट लिख दिया तो कमीशन क्यों लिखा है? कमीशन का क्या मतलब है? इज कमीशन समथिंग डिफरेंट फ्रॉम एन एक्ट? ऐसा तो है नहीं कि उन्हें वो बस उसको फॉर्मेट ठीक लाना था इसलिए कमीशन और कंडक्ट लिख दिया जबरदस्ती। तो ये कमीशन और कंडक्ट क्यों लिखा जब यहाँ पे एक्ट और ओमिशन लिख दिया था? तो यानी कि ये कमीशन और कंडक्ट कुछ डिफरेंट वर्ड्स हैं। आई थिंक दे मीन डिफरेंटली। जैसे हम जब भी अपने मेंस में या कहीं पर भी, स्कूल में भी, कॉलेजेस में भी, जब हम देखते हैं ना क्वेश्चन में लिखा है एक्सप्लेन, या लिखा है एलुसिडेट, या लिखा है इलैबोरेट, या लिखा है कमेंट, या लिखा है कुछ भी इस तरीके का, हमारे लिए वो सब एक ही चीज है ना। हमें सिर्फ लिखना है, जो उस पर्टिकुलर टॉपिक पे आता है सिंपली ब्लर्ट इट आउट। मुझे ध्यान है मेरे स्कूल में एंड इवन कॉलेज में इस चीज के डेफिनेटली मार्क्स अवॉर्ड करे जाते थे जब हम क्वेश्चन की नीड को देखकर आंसर देते थे। बट बट मुझे ये नहीं समझ आ रहा है, वो तो दिख रहा है ना, बट मुझे ये नहीं समझ आ रहा है कि यहां पर जब उन्होंने एक्ट और ओमिशन लिखा तो ये कमीशन और कंडक्ट लिखने की क्या जरूरत थी? कोई पर्पस तो होगा। सो दैट ब्रिंग्स अस टू द क्वेश्चन, इज देयर अ डिफरेंस बिटवीन एक्ट एंड कमीशन? एक्ट और कमीशन में कोई डिफरेंस है कोई डिफरेंस लग रहा है? मैंने ये एक्ट करा, दैट मीन्स आई डिड दिस, आई कमिटेड दिस, दोनों में डिफरेंस लग रहा है। एक्ट कैन बी पनिशेबल और कैन बी डन इन गुड फेथ। कमीशन हियर hints towards the fact that you are doing something detrimental for the opposite party. That is why they have written commission. ये इसको सिर्फ बहुत इलैबोरेट बनाने के लिए एक्ट, ओमिशन, कमीशन, कंडक्ट। कंडक्ट मतलब हो सकता है ना आप कुछ कर रहे हो, एक्ट नहीं है, ना आपको जो करना है आप उससे पीछे हट रहे हो, बट आपका कंडक्ट ऐसा है जो सामने वाले के लिए डेट्रीमेंटल है। फॉर एग्जाम्पल यू आर नॉट ऑब्लाइज्ड, कहीं मतलब आप मतलब मुझे बताओ कि वो जो 7 फेरे लेते हुए या जिस भी टाइम पे जैसे भी आप शादी कर रहे हैं उस टाइम पे जो बातें बताई जाती हैं, उसके अलावा कहीं पर ये क्या मतलब ये लिखा हुआ है कि आप दोनों को, इफ यू आर हस्बैंड एंड वाइफ लेटर से, आपको पूरे टाइम एक दूसरे से बात ही करनी है? या आपकी मदर इन लॉ विल ऑलवेज टॉक टू यू डेली? व्हाट इफ योर मदर इन लॉ सिंपली स्टेयर्स एट यू एंड गोज लाइक दिस? I am not stereotyping. What if the daughter-in-law stares at the mother-in-law and goes like this? Again, not stereotyping. I am just trying to ask you a question. That is why they have written this conduct. You are not doing anything. Are you committing an act? No, you are simply walking. You can't walk like this. है ना? You are simply walking in the house. You are looking in a direction, but it is the conduct which somewhere or the other hints or gives you a reasonable apprehension that something bad might take place. समझ रहे हो? Like the choir at Hogwarts had sung, something wicked this way comes. कुछ तो हो सकता है गड़बड़ हो. For example, I am going to now give you a lot of examples, please don't mind. But जैसे for example, let us say your mother-in-law is cooking in the kitchen. You are also cooking in the kitchen. You both are standing there. There is a house help. The house help enters the kitchen. And for something, the mother-in-law left and right scolds the hell out of that particular house help. Extremely bad, extremely incorrect. This should not have happened. But what if it happens in front of you and the anger is so terrifying? Wouldn't you have this reasonable apprehension that this anger can sometimes be directed towards me as well? That is conduct. Did I do something? कोई act था मेरा आपकी तरफ? कोई omission था? नहीं. कोई commission था? नहीं. मेरा क्या था? Conduct. It was just my conduct. That is what I am saying. That is why to make the definition very broad, they have said that it will include act, omission, conduct, commission, everything will be included here. Let's see the definition. What is the definition of domestic violence? Firstly, they have said harms or injures, or endangers the health, safety, life, limb or well-being, whether mental or physical, of the aggrieved person, or tends to do so and includes causing physical abuse, sexual abuse, verbal and emotional abuse and इकोनॉमिक अब्यूज. अब इन सब की डेफिनेशन हम आगे देखने वाले, तो मैं यहां ज्यादा इलैबोरेट नहीं करूंगा, मैं सिर्फ वर्ब्स पे इलैबोरेट करूंगा. हार्म्स, आपको नुकसान पहुंचा. इंजर्स, आपको चोट पहुंचा. एंडेंजर्स द हेल्थ, सेफ्टी, लाइफ, लिम्ब और वेलबींग. यू आर एंडेंजरिंग, आप खतरे में डाल रहे हो किसी की सेहत को, फॉर एग्जाम्पल कोरोना वायरस, पैंडेमिक, लॉकडाउन, सेकेंड वेव, you push that particular woman outside the house and make her stay outside the house for 5 days, 1 day, half an hour. Is it not endangering the health or life of the woman? Yes, of course. Health, safety, life, limb or limb meaning body, or well-being, whether mental or physical, either the mental well-being or the physical well-being of the aggrieved person, or tends to do so and includes causing physical abuse, sexual, verbal, emotional, economic abuse. उसकी डेफिनेशन हम अभी देखते हैं. आगे, harasses, harms, injures or endangers the aggrieved person with a view to coerce her meaning pressurize her under threat, coerce her or any other person related to her, for example parents, brother, relative of the woman, to meet any unlawful demand for dowry or other property or valuable security. So they are not limited to dowry as defined in section 2 of the Dowry Prohibition Act. They are not saying just dowry, they are saying dowry or other property. It can include gift as well, or valuable security. Gift is also property, I hope you know. It can be both movable, and immovable. So anything that you do against her to coerce her or any other person that you meet my unlawful demand for dowry or valuable security or other property, it will be domestic violence. It will be domestic violence. Yeah? It will be domestic violence. Domestic violence में आ जाएगा. देखिए, has the effect of threatening the aggrieved person or any person related to her by any conduct mentioned in clause A or clause B. या तो आप कर रहे हो या कंडक्ट से क्या कर रहे हो, थ्रेटन कर रहे. By conduct you are threatening the aggrieved person or any other person related to her. आप ये समझ जाइए कि अगर आप aggrieved person के किसी कनेक्टेड व्यक्ति यानी कि अग्रीव्ड पर्सन के पेरेंट्स या ब्रदर को भी परेशान करोगे ना, अल्टीमेटली इट इज गोइंग टू अफेक्ट यू. Ultimately it is going to affect you, right? For example, cheating by personation, yeah, defamation. You tell me, is defamation of a dead person punishable under law? Is defamation of a dead person punishable under law? Yes, because ultimately even if that person is not alive, the reputation lasts and the people who are alive, they might be affected by it. For example, cheating by personation. If a person is deceased and you impersonate that person, isn't that cheating? Yes, that is still cheating, right? 416 of IPC, 416, 417. Good. Otherwise injures or causes harm, whether physical or mental, to the aggrieved person. Now this is a residuary clause. This is a residuary clause. Basically they are saying any other thing that you do. Otherwise injures, causes harm, whether physical or mental, to the aggrieved person. यहाँ नहीं भी लिखा तो भी, if you are in any way causing harm, mental, physical, or injuring mentally or injuring physically the aggrieved person, that will be domestic violence. Now let us one by one look at the different categories of domestic violence that have been given. Explanation 1. Again, I have told you earlier also, explanation is not new, nothing different from the provision. Explanation only clarifies what is implicit in the provision. Okay? I think we are starting on the 9th of March with BNSS at 8:30, right? And we are also starting with Muslim law. I will be starting only. I will be doing BNSS also, and I will be taking Muslim law at 11:30, right? Muslim personal law at 11:30 from the 9th of March. Both of them, right? Okay. How many of you are coming for BNSS? And how many of you are coming for Muslim law? Why not? Sorry? बचा ही एक बैच में है आपके, जो वो 1.5 years बाद आएगा ना, फिर you'll have to wait for 1.5 years. बाकी बैचेस में हो गया दरअसल. मॉर्निंग ये इसमें बचा था 11:30 में बचा था और उसमें बाकी हो गया एक्चुअली. सो you'll have to see for that. कोई बात नहीं, देख लेना, never mind. Physical abuse, that is why on popular demand it is coming. अभी थोड़े दिन पहले कराया था मैंने मुस्लिम. हाँ. So see what is the वो रेकरेंसी, क्योंकि वो साइक्लिकल मैनर में सब्जेक्ट्स चलते हैं ना, दैट इज व्हाई. मींस एनी एक्ट और कंडक्ट which is of such a nature as to cause bodily pain. Now bodily pain, harm, danger to life, limb, health, impair the health or development of the aggrieved person, and includes assault, criminal intimidation and criminal force. Meaning what? That if in any which way you are causing bodily pain, for example, let us say you twist the arm, you slap, you pull the hair, or you, for example, let us say you cause some burn injuries, etc. Harm, it's not bodily pain but simply harm to the body. It might be harmful for the body, right? Danger to life, limb, health, or impair the health or development of the aggrieved person. So you are not, let us say, directly doing it, but somewhere or the other you are impairing. That means you are making it difficult for the person to grow. Understand? You see, every 6 months a person's behavior and way of living changes somewhere or the other. You observe it, it does. So if you have a woman staying in your house and if you do not let her grow, means that you do not let her, for example, if she wants to read, if she wants to recreate, if she wants to go out, if she wants to meet her parents, if she wants to somewhere or the other, spend time, etc. If you're not letting her do that, you are inhibiting her mental growth. That is also domestic violence, and includes assault, criminal intimidation, and criminal force. Assault, criminal intimidation, and criminal force. Fine. And please don't restrict it to husband and wife and everything also. It can be a daughter also. For example, you do not let your daughter go out and study. You lock her up in a room. That is again domestic violence. Sexual abuse includes any conduct of a sexual nature that abuses, humiliates or degrades or otherwise violates the dignity of woman. There is a conduct of sexual nature that there is some abuse. Sexually, if you are abusing the woman, that is sexual abuse. Humiliates, sexual abuse, humiliation. You humiliate the woman, for example, body shaming, or you humiliate the woman sexually. Let us say that you always degrade her while talking about her. You pass sarcastic comments related to her appearance, degrades or otherwise violates the dignity of woman. The sex of the woman, it is her modesty. It is her dignity. You can't infringe upon the dignity of the woman. You can't infringe upon the dignity of the woman. Yes? नहीं, जरूरी नहीं है, बिकॉज अगर प्राइवेटली भी आपको सेक्सुअल ह्यूमिलिएशन का सामना करना पड़ रहा है, ह्यूमिलिएशन ऑफ अ सेक्सुअल नेचर अगर आपको सामना करना पड़ रहा है इन प्राइवेट ऑल्सो, so tell me, isn't it not detrimental for your well-being? Is it necessary that मेरा दुख जब सबको दिखेगा दुनिया को तभी वो दुख माना जाएगा? वो प्रॉब्लम तो परसिस्ट कर ही रही है ना, बिकॉज गलत तो आपने मेरे साथ करा ही. देन verbal and emotional abuse includes, very important, insults. You insult her cooking, you insult her way of being, etc., etc. Be it wife, be it daughter-in-law, be it sister, be it daughter, doesn't matter. Ridicule, humiliation, name calling. You ridicule her. That means you make her look like that she is almost non-existent. Humiliation. You harm her reputation immensely. Name calling and insults or ridicule, especially with regard to not having a child or a male child. You pass comments specifically relating to the fertility of the woman, that she is not able to bear a child or she cannot produce a male child. If this is the case, it is verbal and emotional abuse. It is verbal and emotional abuse. आगे देखिए. सॉरी, नेम कॉलिंग का मतलब है आम भाषा में, वर्नाकुलर लैंग्वेज में, लोकल लैंग्वेज में या स्पेसिफिक जनरल लैंग्वेज में भी कभी कभार आप डेरोगेटरी टर्म्स का यूज करते हैं. उन डेरोगेटरी टर्म्स को यूज करना और उस महिला को उन डेरोगेटरी टर्म्स से संबोधित करना. फॉर एग्जाम्पल, किसी महिला को कहना, इफ शी इज नॉट एबल टू परफॉर्म वेल इन हर एग्जाम्स, that you are unpad. So that is name calling, and that is verbal and emotional abuse. It traumatizes any person. Here we are talking about specifically a woman. It traumatizes any person. If you are name calling that person, if you are doing name calling, or if you are ridiculing that person, it will definitely harm the person's mental growth. That is why you should not simply stamp a person to be a person who is a wrongdoer. Let the person evolve and sometimes even sit as a member of the JJ board. Repeated threats to cause physical pain to any person. Now you are repeatedly threatening that I will hit you or I will cause some physical pain. Now this can be direct also, it can be an indirect threat also. For example, your daughter, let us say if she is not studying, you pick up a stick and you throw it in front of the daughter. Have you hit the daughter? No. But do you think so it is threat that you will hit her? Yes, it is a threat. Yes, it is a threat. I am dealing with all these factual scenarios. For example, if you get a question in the prelims or in the mains examination where there are factual scenarios involved, you should be very well versed with what can be included. आपको ऐसा नहीं लगना चाहिए कि domestic violence मतलब किसी को मारा तब domestic violence, किसी को कुछ बोला तब domestic violence. Simple conduct भी domestic violence हो सकता है. Repeated threats to cause physical pain to any person in whom the aggrieved person is interested. यानी कि उस महिला के साथ आप कर रहे हो वो तो है ही, वो महिला जिसमें इंटरेस्टेड है. फॉर एग्जाम्पल, अ मदर केयरिंग फॉर हर डॉटर, लेट अस से द फादर डज दिस विद द डॉटर, और इफ द फादर डज दिस विद द मदर, डोंट यू थिंक सो द डॉटर और द मदर, बोथ ऑफ देम, दे आर गोइंग टू गेट अफेक्टेड? यस. सो एनी वन ऑफ देम कैन गो एंड फाइल अ डोमेस्टिक वायलेंस कंप्लेंट. आर यू गेटिंग माई पॉइंट? आगे चलते. Economic abuse. Now, economic abuse is something which generally we do not consider. I deal with economic abuse when I talk about cruelty as a ground for divorce in Hindu Marriage Act, etc., etc. But this is also very, very important. Economic abuse includes deprivation of all or any economic or financial resources, of all or any economic or financial resources to which the aggrieved person is entitled under any law or custom, whether payable under an order of a court or otherwise, or which the aggrieved person requires out of necessity, including but not limited to household necessities for the aggrieved person and her children. नॉर्मल डेली रोजमर्रा की जीने गुजर बसर करने के लिए जो चीजें चाहिए आपको, इफ एनी. स्त्रीधन, प्रॉपर्टी. नाउ व्हाट डू यू अंडरस्टैंड बाय स्त्रीधन? See, I will deal with this in great detail when we will be doing family law. But Stridhan, primarily for now, you can understand that in and around the wedding, and even after the wedding and even before the wedding, whatever gifts are specifically given to the woman and they are exclusively given to the woman, that is called Stridhan. It's not just what is given or gifted to a woman at the wedding ceremony or by the relatives. Anybody gifting anything to a woman, that is Stridhan. Property, jointly or separately owned by the aggrieved person. Payment of rental related to the share household and maintenance. If in any which way you are economically depriving the woman, that means you are putting the woman in a difficult situation as far as her economic condition is concerned, be it daily needs, be it rent, be it property, be it Stridhan, it is economic abuse, and that will also be domestic violence. That will also be domestic violence. Next, disposal of household effects. Disposal of household effects, any alienation of assets, whether movable or immovable, valuables, shares, security, bonds and the like, or other property in which the aggrieved person has an interest or is entitled to use by virtue of the domestic relationship, or which may be reasonably required by the aggrieved person or her children or her Stridhan or any other property, jointly or separately held by the aggrieved person, and prohibition or restriction to continued access to resources or facilities which the aggrieved person is entitled to use or enjoy by virtue of the domestic relationship, including access to the shared household. आप मुझे घर के मंदिर में जाके पूजा नहीं करने दे रहे हैं, ये डोमेस्टिक वायलेंस है, क्योंकि इमोशनल अब्यूज तो है ही, बिकॉज यू आर ह्यूमिलिएटिंग. व्हाई शुड शी बी लेफ्ट आउट? यू आर ह्यूमिलिएटिंग हर. At the same time, if she has a right in the property, it is also economic abuse. Why aren't you giving her or granting her access to the household? Getting my point? Explanation 2. For the purpose of determining whether any act, omission, commission or conduct of the respondent constitutes domestic violence under this section, overall facts and circumstances of the case shall be taken into consideration. That means again they are not talking about any isolated incidents. They are saying that you need to understand what is, because see, this I teach in Hindu law also, there is always a very, very delicate balance here. It is not always a series of events, or it is not always the ideal husband and ideal wife. It is always this husband and this wife. What is their scenario? What is their level of patience? What is their situation? Is this something that they intended to do, or was this something which was just situational? These things need to be examined. That is why they are saying the overall facts and circumstances of the case shall be taken into consideration. You will have to consider the overall facts and circumstances of the case to understand whether the particular act amounts to domestic violence or not. Are we clear with this? Are we clear with this? Yes or no? Sure. So, by and large, we are clear with the definition of domestic violence. Section 2 clause A is aggrieved person. Section 2 clause S is shared household. Section 2 clause Q is respondent. And where is domestic relationship? 2F. 2 clause F is domestic relationship. 3 talks about definition of domestic violence. It includes physical abuse, it includes verbal and emotional abuse, it includes sexual abuse, it includes economic abuse also. समझ आ रहा है? Sometimes there are questions asked that Section 3 of the Domestic Protection of Women from Domestic Violence Act 2005 does not include 1, 2, 3, 4. उसमें से कोई एक दे देंगे आपको which is not included in Section 3. That needs to be determined by you. I hope it is correct. Sure? समझ आ रहा है? No questions, no doubts? Okay. Section 4. अब सेक्शन 4 की जहां तक बात आती है, ये अगर आप देखोगे ना तो अब थोड़ा सा ये पर्टिकुलर एक्ट अपनी स्कीम से डिविएट करता है। डिविएट करता है कि मतलब है कि ये एक्ट कहीं ना कहीं अब ना वो जो हमारे लिए इजी रहता है फ्लो ऑफ प्रोसीजर समझने में, उससे थोड़ा सा लेफ्ट राइट जा रहा है। माय सजेशन टू इज 4 to 11 टू बी डेल्ट लेटर। 4 से लेकर 11 तक आप बाद में पढ़ो। आप सबसे पहले आइए 12 सो दैट आपको प्रोसीजर सेट हो जाए। एप्लीकेशन टू मैजिस्ट्रेट, applications to magistrate. Let's see. An aggrieved person or a protection officer or any other person on behalf of the aggrieved person may present an application to the magistrate seeking one or more reliefs under this act. Section 18 to 22 plus 23. 23 is interim relief. 18 to 22 talks about reliefs which can be granted under this act. So they are saying aggrieved person, protection officer or other person on behalf of the aggrieved person can present an application to the magistrate seeking relief. Proviso: before passing any order on such application, magistrate shall take into consideration any domestic incident report received by him from the protection officer or the service provider. There are certain institutions designated who prepare domestic incident reports, who prepare reports of whatever domestic violence takes place in their jurisdiction, and then they can report it to the magistrate. आगे देखिए, the relief sought for under subsection 1 may include relief for issuance of an order for payment of compensation or damages without prejudice to the right of such person to institute a suit for compensation damages for injuries caused by the acts of domestic violence committed by the respondent. They are saying that it does not exhaust or it does not exclude the other civil remedies. That means provisions and the procedure under the Domestic Violence Act, these remedies can concurrently run with other remedies also. That means you can file for compensation in DV Act, you can at the same time file for compensation under civil law. Both of that concurrently is possible, provided where a decree for any amount as compensation or damages has been passed by any court in favor of the aggrieved person, amount if any paid or payable in pursuance of the order made by the magistrate under this act shall be set off against the amount payable under such decree, and the decree shall, notwithstanding anything contained in CPC or any other law for the time being in force, be executable for the balance amount if any left after such set off. लेकिन आपने क्या करा, आपने 1 लाख रुपए की कॉम्पनसेशन आपको लगता है मिलनी चाहिए थी, तो आपने 1 लाख रुपए सिविल लॉ में भी मांग लिए, 1 लाख रुपए डीवी एक्ट में भी मांग लिए। अब ये तो गलत हो गया ना, तो इसीलिए समवेयर और द अदर the set off will take place. That means you're actually going to get probably 70-30, 60-40 or 50-50 from both the forums. You're not going to get 1 lakh each from both the forums. ठीक है, तो वही प्रोवाइजो कह रहे हैं कि अगर आपको सिविल लॉ में रेमेडी मिल गई और आप डीवी एक्ट में भी आते हो तो उतना अमाउंट सेट ऑफ कर दिया जाए। ठीक है, every application under subsection 1, what is the application for? Domestic violence. It is a complaint of domestic violence. Under subsection 1 shall be in such form and contain particulars as may be prescribed. Magistrate shall fix the first date of hearing, which shall not ordinarily be beyond 3 days from the date of receipt of the application by the court. जिस दिन कोर्ट को सेक्शन 12 की एप्लीकेशन आती है, फर्स्ट डेट ऑफ हियरिंग होगी कितने दिन में? नॉट मोर देन 3 days. इफ प्रैक्टिकेबल, एक्सटेंडेबल कुछ नहीं लिखा, मैंडेटरी है, 3 दिन के अंदर ये हियरिंग होनी चाहिए। आगे, मैजिस्ट्रेट शैल एंडेवर टू डिस्पोज ऑफ एवरी एप्लीकेशन अंडर सबसेक्शन 1 विद इन पीरियड ऑफ 60 days from the date of its first hearing. यहां पर they have used the word endeavor. Here they are using the word endeavor. That means कोशिश करिए कि 60 दिन के अंदर आप उस एप्लीकेशन को डिस्पोज ऑफ कर दें। It should be your endeavor to dispose of that application within 60 days of it being filed. Why? So that you can provide speedy and effective remedy. So first date from within 3 days from date of application, and disposal should be between 60 days, within 60 days ordinary. समझ आ रहा है? समझ आ रहा है? Sure. Service of notice. A notice of the date of hearing fixed under section 12 shall be given by the magistrate to the protection officer, who shall get it served by such means as may be prescribed on the respondent and on any other person as directed by magistrate within maximum period of 2 days. और such further reasonable time as may be allowed from the date of its receipts. मतलब कि जो नोटिस है, जो डेट ऑफ हियरिंग फिक्स हो रही है सेक्शन 12 में, उसका जो नोटिस है वो कोर्ट किसको देगा? प्रोटेक्शन ऑफिसर. एंड द प्रोटेक्शन ऑफिसर विल सर्व द नोटिस ऑन द रिस्पोंडेंट विद इन 2 days of getting that particular notice. आगे, declaration of service of notice made by protection officer in such form as may be prescribed shall be the proof that such notice was served upon respondent and on any other person directed by the magistrate unless the contrary is proved. That means if the protection officer declares that I have served the notice, that means the notice is served, unless you prove that the notice was not served. Fine. We'll continue from here tomorrow in the next class. Not tomorrow, whenever the next class takes place, we'll continue from that. Fine. Thank you so much.